SJC-11966, Commonwealth v. William Joseph Sylvester.
Mr. Harris, good morning.
Good morning, Mr. Chief Justice, and may it please the court. My name is Jeffrey Harris. I represent William Sylvester. As far back as 1997, this court has recognized that registration is a continuing, intrusive, and humiliating regulation of the person himself. In the intervening years, that consequence has only become more drastic. Given the changing landscape and the automatic consequences faced by sex offenders, this court should find that there are circumstances under which plea counsel can be found to have given ineffective assistance by failing to give registration warnings. Specifically in this case, under then prevailing professional norms, Sylvester's 2002 plea counsel was unreasonable for failing to tell Mr. Sylvester what very well may have been the most important part of his plea negotiation, and that was that he was going to be registering as a sex offender.
I actually thought the record reflected that he was told that by counsel.
Well, that's a very important issue, and that goes to...
I don't know how important it is, but I'm just saying, doesn't the record reflect otherwise?
Well, so the record reflects that he was told that he would have to register for whatever that's worth. My contention is that being told only that one would have to register is clearly not enough. Similar...
Why not?
Well, because it doesn't have any operative value. The defendant doesn't know what that means. If they were told they were going to have to register, and they don't understand what the Sex Offender Registry Board is, they don't know what a sex offender has to do, then it doesn't mean anything. Very much like the way, as Your Honors have found in the De Jesus case, that being told eligible just doesn't mean anything. The point is the defendant has to have the information to make what Your Honor called in Marino an intelligent decision.
Well, register is an affirmative act, isn't it? I mean, if you're told that you have to register, you have to register. And can't we assume that counsel didn't just say you'll have to register, that there was some explanation of what that means?
I think on the record
why
there
do
was...
we have to go behind that to figure out exactly what counsel said?
Particularly if you've got the plea judge saying you're going to have to register a sex offender as a sex offender with the police.
Well, certainly this court has found on numerous occasions that the court's warnings are not dispositive on the issue of ineffective assistance
No, I
of counsel.
appreciate that, but I just I'm just sort of following up with Justice Hines, following up with what his counsel had said. I mean, is that...
Well, he's going into a plea not knowing what it means to register as a sex offender. I understand even if he was told that he was going to have to register, if he wasn't told what it meant to be a sex offender, like I said, there's really no operative value in being told. Sorry.
What would have been enough?
Well, I think we have to analogize to this court's decisions in Lavranenko and in De Jesus, which look to, and to Padilla itself. Really, the requirement is that the person understand so that they can make an intelligent decision. The specific words, this court has disfavored the idea of giving specific words. The important thing is that the defendant understand the decision that he is about to make and know that he's about to become a sex offender and he's going to have to register as a sex offender. If he doesn't understand that, he can't make a decision in his own best interest. So I would say you have to look to Padilla, and really the duty is as clear as the law is. And here the law is very clear. If you are charged and convicted as a sex offender, you have to register. So to the extent that that is extremely clear, that is the requirement of counsel under Padilla, and it means analyzing.
So what if in Padilla counsel said, if you plead guilty, you will be deported? Adequate? Here, if you plead guilty, you will have to register.
Well, I don't think I don't think you can say that the word deportation and the word register are the same thing, because
Well, they're definitely not the same thing, and one of the
right.
reasons why the Supreme Court said deportation is at a whole different level of consequence than anything else we've considered.
well, you have to also consider that a non-citizen going into a plea understands what deportation is, right? It's something that they may be told, they may understand something about. A reasonable inquiry certainly needs to be made about what their status is. But with a registration, somebody like Mr. Sylvester is going into a plea colloquy not understanding what the Sex Offender Registry Board is, not understanding what the failure to register statute might make him someday have to serve 5 years in prison.
When did
Doesn't
he
it-
first register with respect to his guilty plea and the time he, and in relation to when he first got in trouble for failing to register?
I believe his first failure to register was 2003. And
He never registered.
Yeah, because
never
he
registered.
basically, he was homeless, he was unsophisticated, he didn't even know what it meant. He didn't understand what the court was saying when they said you'll have to register with the police.
And
He had
after
no-
he was prosecuted the first time for failing to register, he was prosecuted again for failing to register?
Like I said,
That's
Didn't
three-
understand.
It's 3 times?
3 times for
yes,
prosecuted.
yes, and
Never could figure.
you know, it-
How's the lawyer supposed to explain something to someone who clearly is not prepared to
well,
understand?
the court certainly has an obligation, a statutory obligation and a due process obligation, absolutely. But really, it comes down to the attorney. And that's why it matters in 2002 that Mr. Collins, who had his own problems, didn't tell Mr. Sylvester what it really meant to have to register. And that
But
set off...
can a judge take all this into consideration when saying, before concluding that, yeah, I'm satisfied that this defendant was properly advised or received a minimal amount of adequate warning, and he understood it?
I'm sorry, can the judge take that into account?
Yeah, can't a judge take all this into consideration and before making the conclusion, a proper conclusion that the defendant was properly advised and understood the warning?
You mean at the plea colloquy or at
Yeah,
the motion?
yeah, at the plea colloquy.
Um,
He wasn't going to register anyway.
Well, if his counsel had told him what it meant to plead to a sex offense, and he had really understood what that meant after the plea colloquy, which he didn't, presumably, I mean, I think that they would have avoided that consequence altogether. There's a reasonable probability of that. But if they didn't,
Being found not guilty if you went to trial? Is that what you mean?
no, I mean, I believe there are special circumstances, and there's, under Clark, a reasonable probability to believe it would have been rational for him to reject it because of special circumstances, or because he would have been able to have another plea colloquy that would have allowed him to avoid such consequences. And Your Honors have found that in DeJesus and in Lavranenko, where people have had very significant charges and gotten really great deals. But that's just not enough. There are special circumstances when someone...
And what are the special circumstances in this case that would correspond with Lavranenko or DeJesus?
Well, again, I'm analogizing, but as a non-sex offender going into a plea, the most rational thing to do as a homeless, unsophisticated person, whether you're counsel or the defendant, is to avoid sex offense registration at all costs. 20 years of that.
But that means going to trial, doesn't it?
Well, under Clark, it may mean if there's a defense, it may be rational to go to trial, but there's also rational to reject the plea because of special circumstances. It may be rational to reject the plea because there's a reasonable probability that another plea could have been secured that would have allowed him to avoid those consequences. And I think there are objective reasons to think, as a first-time sex offender going into this, and not somebody that the Commonwealth would have needed to monitor. I mean, he was 23 years old. It was his first sex offense. He's never had a sex offense since that. It was an indecent A and B for groping a woman's rear end. And that is certainly a serious crime, but it's probably not the kind of thing that was going to, where the Commonwealth is going to prioritize sex offender registration. But we'll never know, because he never pushed back, and neither did his counsel, and said, can we do something where we don't get sex offender registration? Because that would be the worst thing for me. And that's why it's so, I'm sorry.
No, finish your thought.
Well, that's why sex offender registration is so, is really so analogous to deportation, because not only could it be the most important thing, 20 years of registration in this case, but sometimes it's lifetime registration, and it's also intimately.
If he hadn't violated, wouldn't it have been 10?
I'm sorry, you're right. 10 years of registration. He can move for relief from registration after 10 years, but presumptively he will have to register for 20 years.
If we agree with you, do we have to overrule Commonwealth versus Roberts?
No, Commonwealth versus Roberts is a voluntariness case. So, and Your Honors noted in a footnote that the obligation for counsel is broader than the obligation for the court, and for reasons we were just discussing, because the lawyer is really the one who has the obligation to explain what's really going on. Certainly, there's a due process requirement of the court, but no, Roberts. I mean, Roberts is a voluntariness case. Your Honors did, in that context, adopt the collateral direct consequences dichotomy, but I think as Justice Cordy has written in Clark and in Sylvain, that is really not the operative constitutional.
So let me ask you this: it's basically, if we agree with you and say yes, it's constitutionally, well, not statutorily, whatever, ineffective assistance here in this civil proceeding, not to have done a better job of advising. It's not enough just to say you have to register. It's basically all the consequences of pleading guilty that are now enshrined in Rule 14. Does every single one of them mean that all those pleas, if somebody didn't properly or sufficiently advise, they're subject to being reversed?
No, I'm
And
analogizing.
how do we tell which ones do and which ones don't?
Well, the Padilla Court gave the roadmap for that. There is.
Said it was different than anything else.
That's right. It is different from almost everything else. It's not different from registration.
Well, that argument can be made for a lot of things, right?
Yeah, and the reason it's not different from registration is because of prevailing professional norms required warnings, because it's virtually mandatory, except for limited circumstances, much like deportation, because it's a drastic consequence, as this court has found since 1997, but certainly last year's Doe clear and convincing case. And then finally, that it's clear and succinct law. And I would suggest that the law of registration is actually much more clear and direct.
Well, you put a lot of emphasis on counsel's impairment. Are you saying that it was ineffective per se because this lawyer had all the problems that he had at the time?
No.
Why do we need to know that?
Well, it goes to the reasonableness, I think, it goes both to Mr. Sylvester's credibility on the question of prejudice, and it also goes to Mr. Collins' reasonableness on what kind of advice that he would have given.
We don't have his affidavit, so.
Right, and I did do everything I could to get you an affidavit, and I think under Sylvain, this court shouldn't hold that against Mr. Sylvester. This court has found on a number of occasions that it's understandable if the court can't, the counsel can't get an affidavit, but it doesn't appear that it would have mattered. As I've written in the record, I'm sorry, as is in the record, he said that he didn't remember any of it, and I think there's a good reason to think that he wouldn't. He was on cocaine every day. He couldn't practice law safely.
Well, he was asked specifically about this case, or was it
No.
in general, about his practice in general?
Well, he was asked specifically about those months, and that summer and that fall. And I just point that out because it's consistent with what Mr. Sylvester told me about what happened in this case. And I think it really, it distinguishes this case from a lot of other cases. And it goes to the credibility of Mr. Sylvester and what he said happened.
Just one last question. In 2002, was there internet dissemination of level 3 offenders?
No, there was not.
That began when?
You know what, I'm not absolutely sure. I believe it probably began after 2010.
Okay,
But
so
that's-
it was certainly not in 2002.
No, but nevertheless, failure to register, employment, housing, discrimination, this court has recognized going way back that this is a significant consequence.
Okay,
Thank you
thank
very
you.
much, Your Honor.
Good morning, Chief Justice, Justice of the Court. May it please the Court, Suzanne O'Neill, Norfolk District Attorney's Office for the Commonwealth. This court should affirm the order denying the defendant's motion for new trial for 3 reasons. First, the motion judge, who was also the plea judge, did not abuse her discretion in finding that the defendant had been advised of his obligation to register by both the court and defense counsel, although he wasn't required to, and she properly applied Schindel to this case. Second, the defendant's reading of Padilla and Clark is plainly wrong. Those cases are limited to immigration consequences, and neither remove the distinction between direct and collateral consequences of a plea.
Ms. O'Neill, how many, I think two, but how many courts from other jurisdictions have basically applied Padilla to sex offender registration?
Your Honor, I believe I have it at page 14 of the Commonwealth's footnote 14. It was a handful of courts. It's a military court, and there are special requirements under the Military Code of Justice, so the military court has applied it. New Mexico has applied it, but in that case, counsel affirmatively misadvised the defendant.
Right.
It's been done in Georgia, but there was no mention of registration during the plea. There's an unpublished decision from Iowa in which the court held that confinement as a sexually violent predator is collateral consequence, but in that case, they said it was beyond the scope of counsel's duty. And then People versus Fawnville, it's a Michigan case from 2010, in which they didn't hold that Padilla required it, but they adopted the reasoning of Padilla to the sex
That's the
offender cases.
Michigan, not the Supreme Court, but the Court of Appeals, is that right?
Your Honor, I
Doesn't
don't
matter.
know.
But
But
they've adopted the reasoning, okay.
I did do another check, and it hasn't been, New York has rejected it, California has rejected it. Across the country, it hasn't been adopted, this finding that Padilla is that expansive, but generally those courts have limited it to the immigration consequences because they are so unique and it is so drastic.
Does the record reflect whether or not the CPCS manual for standards of performance for public and private counsel address this specific matter?
The defendant has included it in his record appendix, but what it does say is it says counsel should advise of sex offender registration. It doesn't go beyond that, and in this case, that is exactly what counsel did. But I'd also say,
And that's been there since when? Do you know?
1999 or?
At least, well, the sex offender registry first came into existence in 1996, 1997. Then it was revised in 1999.
Yeah.
But I'd also say in terms of that, there's, whether within the CPCS performance manual or if you look at a MCLE or a Blumenson going back on pleas, there's a number of different things that all of those materials recommend that defense counsel advise their clients of.
It doesn't constitutionalize those things.
Correct, Your Honor. It's work issues, it's child custody issues. There's any number of things that can be affected by a plea, but it doesn't become a constitutional issue. And part of that is in large measure, you can't predict the time of the plea. When this defendant pled in 2002, many of the effects of being a registered sex offender were very different. In terms of the internet dissemination, that was added to the statute in 2003. It was amended for level 3 sex offenders, and then it was revised later in 2013 for level 2 sex offenders.
So, well, first of all, you had 3 reasons. You've only given 2. So we're all waiting for your third, which I know you were interrupted before you were able to give.
Sure. My last on that was that although the sex offender registry does carry serious burdens for defendant, it is simply not on par with immigration consequences. I would add as a last measure that in terms of where we were in 2002 when this defendant pled, and I think one of the most striking things about thinking back in time is that if you look at the facts of the case, one of the witnesses, one of the young teens at the train station, had change in her hand to go use a payphone. And things have changed so dramatically since then, that's not in existence anymore. But the other thing is that on our plea sheets now, the green sheets, it includes sex offender registry. In fact, it's on the face of the complaint that the defendant would have to register for this offense.
Are the implications of that, you're suggesting that just to say you're going to register, someone's going to know that for the next 20 years of their life, they're going to be restricted. People are going to know what they've done, and they're going to be restricted where they live, who they can meet with, who can be in contact with. There's the restrictions, according to our cases as well as those of the Supreme Court, recognizes that impinges severely on someone's liberties. It's a huge impingement. It's not small.
I'd say to that, it's the conviction itself. Yes, there are implications from being a registered sex offender.
For groping.
But housing and employment, all of those stem not from being while certainly there is a categorical implication for being a registered sex offender, the offense itself is going to have implications for a defendant. And so I don't think that we can overturn or import this into the constitutional or impose it on immigration when it's really, this isn't just about the registry. I mean, all these consequences that someone faces long term are because of the criminal record, are because of the conviction. And particularly for this defendant.
Day and age, it's also because you're 19 and your girlfriend's 16, or because you're stupid and you grope someone.
Right, but that's not this case. This defendant, when he pled to this offense, had 16 convictions for which he had been sentenced to time at the House of Correction. He had 3 restraining orders against him. After this conviction.
You mean 209A orders?
Correct. One had happened just before this. So while there are serious consequences down the road for a sex offender, I'm not sure that, the performance standards say, advise the sex offender registry. That happened in this case. So even the defendant now hasn't said what more is that, and how do we delve into the conversation between counsel and the defendant when the court conducts that plea colloquy and says, have you been adequately advised? How do we subjectively go back when he says, well, 4 times I've been charged with this. It must be because he didn't explain it to me adequately in 2002. You simply can't do that when the court.
In every case, or is it just this case? Is it because it's 4 times, or do we speak just to this individual, or do we speak to individuals similarly situated for the future who are subjected to registration that they're not informed of what the implications are and how severe the consequences of failing to register are?
Well, that's where I think we have to rely on that plea colloquy, because otherwise with anything we'd be asking after the fact. You say, I violated law, it must have been because my attorney didn't tell me. But in this case, as in cases going forward from this, because from at least 2006, it's been on the green sheet for the plea colloquy, and it's been put into Rule 12. So it's part of the plea colloquy, and this judge said she's always given it, and that's the case across, presumably if everyone's following the plea, you have to put some reliance upon when the court says, have you discussed this with your attorney? Has he adequately explained it?
Right. The question here is his attorney's obligation, correct? I don't think we're doubting here the judge's obligation.
Right, but the court has to be able to put some some faith or some confidence in that plea colloquy, and so that if it's a case of affirmative misadvice, you might have a different circumstance. But in this case, the defendant is told, he says to the court, I understand, I've been advised, the court advises him. He doesn't say he's violated his probation by February, so he pleads in November. By February, he has violated his probation. One of the ways he's violated it is he had failed to register. He didn't at that time say, I don't know what that means. He wasn't charged for that. He is violated because it's also a shoplifting, and he does the final year of his sentence. He then violates again by fails to register. He doesn't at that time say, I don't know what this means.
Okay, let me ask you two questions. Put aside Mr. Sylvester in 2002, okay? It's 2016. Do you agree that counsel is ineffective where counsel does not discuss with his or her client the fact that the person, by pleading guilty to a sex offense, will need to register and potentially may be subject to internet dissemination?
I think it's an important part of the attorney-client privilege and should be discussed, but I don't think it rises to, I don't think it gets into that same basket with immigration and the other components of a plea that counsel is constitutionally required to discuss. I don't think there's a basis to go past immigration consequences for ineffective assistance counsel.
Let's speak of the first prong of Safarian, okay? Falling below that which we expect of the ordinary fallible attorney. Do you agree that the failure to discuss this today with a client before they plead guilty to this crime falls below that which we expect from the ordinary fallible attorney?
Fallible attorney.
Correct. Well,
Ordinarily.
or the serious incompetence of the ordinary fallible attorney.
Right.
My difficulty with answering that question, sir, and I don't mean not to answer it, Your Honor, is it is part of the plea colloquy that counsel has advised the client of the sex offender registry, of the obligation to register.
But doesn't that at least say, I mean,
So-
doesn't that go to it? And that, you know, you're about to be, when you plead guilty, the judge is going to tell you this.
Right.
Should that be for the first time that the client learns of it?
Well, but that, I think that's what I'm saying, Your Honor, is it's on the face of a complaint that will say this is part of the penalty. And then they have the green sheet, so the client discusses it with counsel. And then it's part of the plea colloquy as well. And so I think my answer to your question is, if you're in open court and counsel says, response to the court, I have advised my client, and the
But I'm sorry, but is that part of the colloquy, or does the colloquy merely say you are advised that a consequence of this may be?
Oh, you're talking
Well,
about
I
the
guess-
green sheet now.
The green sheet, yes.
Okay,
And
so you're
and
saying,
counsel
so the green sheet, which was not signed, which was signed here by the client as opposed to the attorney,
Well, it's signed by both.
Yeah, and this is
I gather-
2002. You're talking about 2016 now. So there's a green sheet. Explain.
so
There's a green sheet.
The green
and it-
sheet today says what? The attorney is saying what? That yes, I have discussed this with my client.
Yes, it is. It does in fact say that.
Okay, so there is the green sheet confirmation that the client has discussed this with counsel.
Correct.
Should that be part of the colloquy as well? Should the colloquy say not only that you are informed, but should confirm that indeed you have discussed this with your attorney?
I believe that is part of the colloquy, because one of the questions that the court asked the defendant is, and you have had time to discuss this case with your attorney, and you have had time to discuss the sentence, and you've had time to discuss whatever the particular words the judge will use, but that is part of that discussion. That is part of the plea colloquy, whether or not counsel has gone over all of these factors with the defendant. And so what I think maybe my answer to your question is, this is that part of the colloquy says, yes, the attorney and client have discussed this. How you get to that part of the colloquy without having discussed it, that's the point in time when a defendant may raise it. But if we go later and say down the road, subjectively the defendant says, I didn't understand, I think that's where we get into trouble, because you do have on the record, and it should mean something, when the defendant and the attorney represent to the court that they have discussed it.
Have you submitted the green sheet as an exhibit?
Not the most recent, Your Honor.
When did the green sheet go into effect, or when was it first implemented, do you know?
This one or earlier ones?
So I did look, I can say definitively as of the 2006 green sheet contained the statement that
Counsel's statement that he advised the
I
person.
have been advised, yeah,
And the defendant's acknowledgement of that advice.
correct. And then it was,
About 2002, when the plea was actually made here.
the plea sheet in this case does not contain that specific advisement.
So we're really talking about something that doesn't apply to Mr. Sylvester.
Correct, because Chief Justice had asked about 2016. So and at least the revised version from 2008 and 2009 contained the sex offender language. The 2002 did not contain that language. But in this case, for this specific case, we have it on the docket sheet that it's recorded the defendant was advised. The judge herself, who is the plea judge, was also the motion judge, has her recollection that this is what she's always done. It's always been her practice. And the defendant said that he was told by counsel. And now, I recognize he said registered, but at this point, we have, the defendant has then, I don't think you can say because he failed to register that he wasn't properly advised.
Do you agree with your brother that if we agree with him, that the holding of Commonwealth versus Roberts is unaffected?
I don't agree. In Roberts, the court went back to that direct, affirmed the direct collateral distinction between the consequences. It did discuss it was under due process in the Fifth Amendment and a voluntariness of the plea, but I think that's.
Go ahead. It's upset that you're over your time, but I think, but
I
go ahead.
apologize.
It's,
I do think it would overrule Roberts. I think Roberts is very clear that that divide remains. Thank you very much. I ask the court to affirm the order denying it.